So the reprogramming that part wouldn't work. Did you want us to move some benches or something?
Yeah, that would be great.
Where are they coming from?
Sorry guys, I'm just gonna mute myself.
Yes.
They're coming from the other courtroom.
Let's just ignoring this one.
So we can take the long one behind there.
You've got your card on?
Yeah. No, I'm not doing it. Oh, if you can have it. Thank you.
I'm just going to like it. I just.
Oh, yeah.
There you go. And
The second one. Unbelievable. Yeah, maybe I should have tried this earlier. Yeah. Should I try ending everything and starting it again? It looks like it is on mine. It says live for 2.5 minutes. Yeah, I made it private. Yeah. I can make it public again, but then. He's gonna know when to see it.
We won't be starting.
I have printed.
Yeah.
I reckon there's more in there, that's why.
You know what? Where's the airports are blocked out? Actually, I'm blocked off, aren't I? Sure, we'll be cleaner plugs in. Somewhere. This is gonna be this is not going to set up at all because there's normally dark lights, no PowerPoints everywhere.
Probably a bit usual. Sorted.
I'm not sure she's an electrician. Printer on the floor. PowerPoints down there. No. Nothing down there. PowerPoints are there. Maybe we could just come and sit here. I knew I should have put my fucking laptop on charge.
Yeah, nice.
In fact, I might try and get it now. Get some charge. Trouble. One need that. Put it in over. So,
Pound back to these people. Oh, yeah,
No, so I'm saying they normally have
There's pound there's a lead running down me.
one lead.
Okay, so um so now it's selected display courtroom.
Okay, there's a multiple display courtrooms depending on what you're looking at. So there'll be one for video conference, one for
Yes.
computers, one for.
Yeah, I'm on the computers one.
There we go. Now see stuff here.
Oh, okay.
Yeah.
Okay. Yeah. Yeah, I did. But it's because on mine, like right now, display to courtroom for computers is selected.
Yeah, it just went big again.
Mention it.
That's fine. So what happens is when you're actually sitting in front of a computer, you'll actually see the
Well, I do remember the city.
Okay. So does it look like everything's good and running then?
Well, I'm very concerned at the moment is that
Okay, so I'm gonna again. Split my screen.
Oh, that's good.
are you
I'm just going to take the Coronial. Oh,
Yes, I am.
I know.
We did all this before.
Okay, so now I've put it on extend my screen.
No, how good.
No.
You got no power over here.
I'm over here.
Oh, you're over here.
But
we don't need this one.
no, because I
Do you need help?
But I don't know where sitting it. We'll just.
Charge now.
right. Well, we've got to find the one for the journos. So I'm going to go and take.
Done one, we'll just.
Yeah, do it.
Okay.
Okay, Mazzy, I can't get out.
We don't have them on the back past, I believe.
I can't get out without you, and I need to get my printing. So I'll come with, and then I'll come back.
just remember, because you've got to share that up, just remember to
Morning,
go to the
guys.
YouTube page and everything is up and up.
Yeah.
That will cause that thing.
Okay. And
You want to just leave it playing on mute or something so that.
yeah, can I just leave it now?
You can put that YouTube page of. I'm going to make it public first, so we'll have the privacy settings on that YouTube video to public.
Can I do it while it's playing, or I need to end the stream and do
Yeah,
it?
we can.
Okay, I might turn off our microphone.
And we all raced back. And then I got a phone call from my daughter-in-law. Yes, so and so has been shot. Yeah, and we all started. And that was all, just too much, just too much. Get over that feeling, every time we got to think about it. We all cried in our cars, all driving back to that house. Everybody went into their house, what they saw there, it's really, sadness, came over them, what they saw, and then went out of the house, just crying. We all said,
Just don't know. I think
Good morning, Dr. Dwyer.
Good morning, Dr. Prickle.
sorry, it's like a little. What's going on here? I don't know, man. I don't know. No, these are usually someone's put them here. I always claim one, but like take
Junior solutions and I will.
Like, you know when you start there. And done this before. Really?
once or twice. Yeah. It's nice to have you. Nice to come again.
Enormous bag. I will not be taking up this much space.
Are there 2 laptops necessary?
Yes.
Yeah, okay, sure.
So not everyone was diligent in reading our submissions is maybe so. We appreciate that.
No, they just I deleted it and tried to put it back. And if I copied it into a new document, it would.
Michael need a plug-in.
For a while, and it looks like it may have been enough.
Oh, that's great. Thank you so much.
And thank you for that.
Thanks very much.
It works.
Morning, how are you?
Do you reckon anyone's have a seat with it? I think A will come in.
We're going to make sense.
Do you mind if I put this for you?
Well, actually,
Go for it. Yeah.
Oh, I'm sorry.
Oh, that's nice. Much clearer.
And I actually got some.
Good morning, Mr. Reid. It's Peggy. Can you hear me?
Hi. Yes, I can.
Nice to see you, Reedy.
Oh, who's that? Maslin?
It's Peggy. It's not Maz, it's Peggy.
Oh, g'day, Peggy. How are you?
Well, thank you. I'm just logging on briefly with you to say, would you like to put yourself on, as much as we like seeing you, would you like to put yourself on mute and turn your video off, or would you prefer to be seen? Matter for you.
Oh, I don't want to be seen. No. Well, I did have a shave this morning, especially for it. But anyhow, I'll mute. Okay.
Thank you. Thank you.
Righto. Good on you, Peggy. Good luck today.
Thank you, Mr. Reid. Bye.
So it's two.
Psalm 16. The Coroner's Court of the Northern Territory is now in session. Please be seated.
I acknowledge that today we sit on the lands of the Aranda people, and I pay my respect to their elders, to First Nations people present in court or following from afar. You are welcome here, and I pay my respect to your elders. Ms. Dwyer.
May it please the Court. Your Honour, I appear as your counsel assisting in this matter. I appear with Mr Coleridge, who can't be here today but has been here throughout these proceedings, and we are instructed by Ms Maria Walls.
Thank you. I'll take other appearances.
Good morning, Your Honour. If the Court pleases, my name is Mullins, initials GR. I appear with Ms Moreau of Council, instructed by Prudence Watts, who is not with us today, of Streeton's Lawyers.
Thank you. Thank you.
Good morning, Your Honour. My name is Beau. I appear with Greer Beau, Claire O'Neill, Dan Fuller and Andrew O'Brien, all of whom are unable to be here today for the Walker Lane and Robson films.
Thanks, Mr Beau.
If you want to please us, I appear for the Purrumburu Committee with Mr O'Brien. We're instructed by Dugan George.
Thank you.
Please the Court, Your Honour, my name's Murphy and I appear for Naja. I'm led by Mr Bolton SC, who appears online, and also led by Mr Espy, and I appear with Mr Derrick and Ms Mishra.
Thank you very much.
May it please Your Honour, I appear with Miss Bernard. My name is Freckleton, and we're instructed by Miss Lau. We appear for the Northern Territory Police Force, including various specific members of it.
Thanks, Dr Freckleton.
Your Honour, please us, Luke Officer of Mr Roll, led by Mr Abbott KC, Mr Edwardson KC, Mr Brennan.
Thanks, Mr Officer. Others? Sorry.
Sorry, Your Honour, I was waiting for Mr Reid. My name is Oslins. I appear with Miss Young for the Northern Territory Police Association.
Thanks, Miss Oslins.
May it please the Court, Your Honour, my name is Hutton and I appear on behalf of NT Health.
Thanks, Mr Hutton.
Good morning, Your Honour. My name is McCarthy and I appear on behalf of the former Territory Families Housing and Communities.
Thanks. I think we're up to you, Mr Reid.
Mute.
Mr Reid, you're on mute. That's okay. I can see that you are there. And Mr Reid is for Constable Eberl and Constable Hawkins.
Yes, that's the case, Your Honour. Officers Eberl and Hawkins. Your Honour, might I just point out also that in court we have a number of family members, and I know Your Honour particularly welcomes them to this court. Eddie and Lottie Robertson are here, Rakesha Robertson is here, Derek Williams and his father Warren Williams, and Alice Walker-Nelson.
Thank you.
Your Honour, might I also say for the record that a literature interpreter who has assisted us throughout these proceedings is here in court, and we're very grateful for her assistance.
Thank you so much for being here. We really appreciate the work that you're doing.
Unfortunately, a Warlpiri interpreter could not be available, and it's one of the difficulties we have experienced is the struggle to get interpreters who are available, and Your Honour might reflect on that further, but we did order a Warlpiri interpreter and sadly none has been available. Thank you.
Thank you.
Could I also indicate to Your Honour that the Deputy Commissioner of the Northern Territory Police Force, Mr Dole, was present, as is from the Executive, Ms Leanne Little.
Thank you very much.
Your Honour, I just mentioned that the Lane family were scheduled to arrive. Their vehicle broke down, so they haven't been able to come, and one of their family members has been hospitalised, but they have a great interest in the outcome of these proceedings.
Thank you. I'm sorry to hear about that. I hope that's all successfully resolved.
Yes, thank you.
Yes, Dr Dwyer.
Thank you, Your Honour. As Your Honour knows, time allocations have been given this week for oral submissions in reply and or any oral submissions that parties wish to make. We have only 2 days for that process, and so I just thought that I would start by setting out a little bit about the process that has been engaged in to date and will be engaged in over the next 2 days. The inquest into Kumanjayi's passing began in early September 2022. It was scheduled to run for 3 months and to finish in early December 2022. It has obviously taken much longer than was anticipated to complete these proceedings, and these are the final stages. The reason it has taken much longer is not simply due to one reason. Firstly, certainly the issues were more complex and required further evidence. But the primary reason that the length of the inquest has blown out is because there were a number of legal challenges made by other parties to proceedings, all of which were unsuccessful, but which had to be accommodated by Your Honour. That's not a complaint by counsel assisting that those legal challenges took place, but it is just an explanation that the public should understand as to why these proceedings have taken longer than anticipated. And it's also then important that we understand the imperative of finishing these proceedings and allowing Your Honour to get on with the important task of writing your findings. Throughout this process, in my respectful submission, every effort was made to be careful, to be thorough and to be fair and to engage the community in this process. And these oral submissions continue with those principles. Counsel assisting is mindful at all times of procedural fairness that must be afforded to parties. Procedural fairness is a flexible principle. It depends on the circumstances, but it's certainly accepted that in the coronial context, it includes that before a decision is made, which is adverse to a person's rights or interests, they must be given an opportunity to provide documents or give oral evidence that contradict the adverse information. In this case, there has been ample opportunity for parties whose interests are affected to respond to any potential criticism or comments that Your Honour might make in findings that are adverse to them. All parties have had an opportunity prior to today to put on written submissions. There was no word limit to the written submissions that could be received. Your Honour has received written submissions from counsel assisting that are some 297 pages, and of course I can't hope to cover them in the time slot I'm allocated, which is 2 hours. Your Honour's received submissions from the Northern Territory Police, from the Northern Territory Police Association, from NAJA, from NT Health, from NT Housing, from individual officers, including Rolf. After the exchange of submissions, there was a further opportunity to put submissions in reply, which many parties have taken the opportunity to avail themselves of, including Parties for the Families and Mr Rolf. There are some 1,990 pages of written submissions for Your Honour to absorb. In initial submissions put on behalf of Mr Rolf at paragraph 205, Mr Rolf contends that if the coroner, contrary to the submissions advanced in those written submissions, intends to make any adverse findings against Rolf, there is a duty to give him notice of that intention and an opportunity to make submissions with respect to it before moving to final publication of any findings or comments. That submission is, with respect, misconceived. This is the opportunity. That is the opportunity that has come to date and the opportunity today to respond to any potential criticisms. In some commissions of inquiry that I'm aware of, there is sometimes, and often sometimes in lieu of written submissions, a draft finding, but that is not the process that is routinely done in coroners' courts. It's not a process I've ever encountered in the Northern Territory or in New South Wales in literally hundreds of inquests that I've been involved in. There is no obligation to disclose provisional findings or conclusions. See, for example, Minister for Immigration and Citizenship versus Zagur SZGUR 2011, High Court of Australia 1, 241 CLR 594. And in the Northern Territory context, Laurie, Lawrie v. Lawler, LAWLER 2016, Northern Territory Court of Appeal. The Walker Lane Robinson family helpfully deal with this also in some detail in their submissions. The process being followed here in relation to an exchange of submissions is the ordinary process followed in the Coroner's Court in Northern Territory, New South Wales and other jurisdictions throughout Australia. The ordinary process is being followed here and every opportunity for procedural fairness has been provided for. At the end of this week of submissions, I propose, Your Honour, to circulate draft recommendations that, in my respectful submission, I certainly will hope to make practical, sensible and capable of implementation. I do not propose to make any recommendations in relation to individual officers, but rather directed to government departments or institutions. And I suggest, Your Honour, that parties be given 14 days to respond to them so that instructions can be taken. I anticipate being able to circulate those draft recommendations next Tuesday, and 14 days hence would make it the 17th of December. That will allow, Your Honour, then to have the Christmas and January period and beyond to think carefully about your findings and recommendations. As often happens, I just note this, some reforms have already been implemented through as we have gone through this coronial process where issues have arisen and departments have had the opportunity to respond to them. And I note in particular that I anticipate, Your Honour, will hear from Northern Territory Police about a number of changes or reforms or improvements that have been made on reflection. Take, for example, at paragraph 1322 of the submissions on behalf of Northern Territory Police in relation to parts of the recruitment process. And institutions are to be applauded, Your Honour, in my respectful submission for taking initiative. Where they have done so, there is likely to be no need for a further recommendation, and Your Honour can just note that in your findings. Before I commence in relation to the evidence then, Your Honour, just one further thing about the coroner's process. Your Honour's role is of course governed by the Coroner's Act. Section 15 of the Act provides that an inquest is mandatory in these circumstances. So that means Your Honour was required to have an inquest in relation to Kumanjayi's passing. And the only other section of the Act I want to refer to is section 26, which is an important one. It states that where a coroner holds an inquest into the death of a person held in custody or caused or contributed to by injuries when they're in custody, the coroner must investigate and report on the care, supervision and treatment of the person whilst being held in custody or caused or contributed to by injury sustained while held in custody, and may investigate and report on a matter concerned with public health or safety in the administration of justice relevant to their death. The fact that the Northern Territory Coroners Act has picked up and put in a section that requires a coroner to report on the care, supervision and treatment of a person in custody comes directly from the Royal Commission into Aboriginal Deaths in Custody, reporting in 1991. A coroner who holds an inquest into the death of a person in custody must make such recommendations with respect to the prevention of future deaths in similar circumstances as the coroner considers to be relevant. The Northern Territory Police Force, in their lengthy and helpful and detailed submissions, describes Kumanjayi's death as tragic and avoidable. With respect, your counsel assisting team agrees with that description. It is another reason why this process is so important. Kumanjayi's death has been devastating for his family, his community, and it has caused great angst and suffering from the many individuals involved, including the officers involved on the 9th of November and those based, in particular those based permanently at Yuendumu or who have worked at Yuendumu. It's caused grief in the broader Northern Territory Police Force, and recommendations will be aimed at preventing a similar tragedy. I have already mentioned I can't hope to cover all the areas in my written submissions or in reply to each of the submissions in the time allocated to me, but I propose to outline 6 broad areas and in the process reply to some of the more significant points made by other parties, and I otherwise rely on the written submissions. Council assisting maintains the position adopted in written submissions and doesn't withdraw or retreat from them. So the 6 areas that I propose to outline are, firstly, starting with Kumanjayi's life and the circumstances in which he grew up in Yuendamu, which will lead to recommendations relating to better supports for youth and community from the earlier stages of a young person's life to minimise the risk of similar death. Second, the events of the 6th of November 2019 and the attempt to arrest Kumanjayi by officers Hand and Smith. Third, issues relating to former Constable Rolfe's history and the relevance of that history and conduct to the 9th of November 2019, including the process of recruitment, instances of his use of force, evidence of attitudes of racism, sexism and lack of respect for community police and poor mentoring. Fourth, the events of the 9th of November 2019 and the attempted arrest by former Constable Rolfe and Officer Ebel. Fifth, in brief, some of the actions after Kumanjayi was shot. And finally, the need for better supports for our police officers in the Northern Territory in order to assist them in their challenging work and to minimise the risk of similar deaths. It's obvious from the length of the submissions that although Your Honour is bound by the Act, and this is not, of course, a roving royal commission as parties are fond of reminding coroners at times, the process would be inadequate if the court looked solely at the events of the 9th of November in isolation. In order to fairly evaluate the circumstances of Kumanjayi's death and in order to make meaningful recommendations, Your Honour will view the evidence fully and fairly and in the context of the environment. There's no room for black and white thinking. This is not about taking sides between Kumanjayi and officers involved. All of those persons who I'm about to talk about are more than the sum of what happened on the 9th of November, and the court understands that. Starting then with Kumanjayi's life and the circumstances of Yuendamu, the final stage of this inquest comes just 2 days after Your Honour released findings that were detailed into the deaths of 4 women as a result of domestic family violence. And Your Honour has highlighted the scourge of domestic family violence in the Northern Territory and the fact that the statistics in this jurisdiction far exceed the jurisdictions throughout Australia. Your Honour said this in your findings at paragraphs 115 to 116. We must acknowledge and understand the connection between a child being exposed to domestic and family violence and that child being involved in the youth criminal justice system. A 2022 Australian Institute of Criminology research paper found that 65% of children involved in the justice system had been exposed to family violence. In the Northern Territory context, a recent analysis by the Office of the Children's Commissioner found of the children aged 10 to 13 in youth detention in the Northern Territory, 94% of those they spoke with had been exposed to family violence. There is frequent media reporting about young people in the Northern Territory committing crimes like house and shop breaking and stealing cars that generate fear and resentment in the community. Given the statistics, it is likely that many of the young people on the street are on the street because their homes are not safe, as one parent is the victim of violence at the hands of another. Your Honour, Kumanjayi Walker's story exemplifies exactly what Your Honour has said in the context of the domestic family violence inquest. Because, as set out carefully in the submissions of the Brown family, from the age at least of 4 to 10, Kumanjayi was exposed at home to a relationship, and I quote, plagued by excessive alcohol consumption and domestic violence. What Your Honour quoted from the Office of the Children's Commissioner was that of the children aged 10 to 13 in youth detention that they spoke with, 94% had been exposed to family violence. Kumanjayi would have fitted right within that statistical analysis. In addition to that, exposure to trauma and violence, the court heard evidence that it's likely he was born with FASD, that is fetal alcohol syndrome disorder, and he experienced the impact of that disorder, including poor impulse control. He also experienced hearing loss and related difficulties at school. He had periods of being teased. He was homeless as a result of those behaviours. These are dealt with carefully in the submissions of the families and Paramparoo. And, Your Honour, I commend to you in particular the submissions of the Walker Lane Robinson family, for example, at page 16, where the submissions cite Sergeant Jolly, who obviously cared about Kumanjayi during his lifetime and was very upset by his passing. You'll see that she was taken to a note in submissions where she was spoken to on the 7th of April prior to Kumanjayi's passing, and she advised that because of his behavioural issues, there was a perception he was no longer welcome at Yundamu. Sergeant Jolly explained that while he was cared for, there was no responsible adult to look after him, and he never received care like a child deserves. That was her concern for him in the community. She said that Kumanjayi walks around the community, he was suspected of breaking into places, and there was a concern that he had a negative impact on young children. She was concerned that around that time he was sleeping on the floor at the church in a dirty swag. And she said, he's a troubled young man through no fault of his own. It was put to her that there was no mental health or cognitive assessment done for him in 2017. And she said she agreed that that was troubling, and it appears to have let him down. And that is the case. Your Honour, we seek then findings that are set out in some detail in the submissions of counsel assisting at paragraph 20. Sorry, at page 21. I might just hand to Your Honour a copy of those submissions. I think Your Honour has the other submissions on the bench. At page 21, paragraph 62, in respect of Kumanjayi's story, Your Honour should find that he suffered from health conditions that impacted negatively on his behaviour and contributed to conflict with authority, including fetal alcohol syndrome and hearing loss. He was exposed to trauma, particularly domestic violence, which likely contributed to his own negative behaviours, including his exhibition of violence. He was capable of kindness and connection. He thrived in structured environments, and his story illustrates starkly the need for early intervention and appropriate support structures. Your Honour will recall that Kumanjayi thrived in the environment of SevGen in Queensland with a 6-month structured program, and he thrived in a 6-week program at Mount Theo. They were structured environments with good supports away from alcohol and with people who focused on trauma-informed response. There are a number of recommendations that I will suggest to you on follow from that, but in particular, one that comes from the expert evidence of Dr. Boffa and Dr. Jonna Archie of Congress. Your Honour will recall the evidence that they gave in relation to the need for early intervention to deal with children who've been exposed to alcohol and trauma. They are truly experts in their field. And it's clear from the evidence that Your Honour has heard that there are so many more children like Kumanjayi who need that intervention now if we're to prevent adverse interaction with the Territory Police. So I propose to direct to Your Honour a recommendation along these lines to Northern Territory Health that primary health care practitioners should be arranged and funded to screen all children under 5 in clinics in remote communities for developmental delays that could indicate FASD using the ASQ, Ages and Stages questionnaire development assessment tool, which was culturally adapted. There's an equivalent ASQ track. And that if there's an indicator for FASD, they should be referred for an early childhood intervention plan under the NDIS and resources devoted to the implementation of that plan. And secondly, that Northern Territory Police and Health should work together to design a process for referral of children who have repeat negative interaction with police to primary health care practitioners for that ASQ track screening. To prevent another tragedy, we need a holistic approach that recognises the strengths and challenges for the children of Yuendamu and in similar communities. That's why the submissions of your council assisting team and others, including Paramparoo, set out the history of Yuendamu and why Your Honour has the work of historians and anthropologists to draw upon in the brief. To understand the trauma of those in Yuendamu and surrounds and the reasons for the ongoing poverty for children and young adults, it's important to understand the history, not just of the Coniston massacre, although that's important and Your Honour has evidence of it and it's seeped into the memory of the community, but also the fact that sedimentisation of the people of Yuendamu and the removal of Walpuri and Luricha and communities from fertile land, the destruction of their habitat, the unsuitable housing, the disruption of culture, all has an ongoing impact on and relates to the poverty of certain. The court will understand the deficits and work to improve the strengths of the community of Yuendamu. It's why, in my respectful submission, there should be a recommendation for culturally appropriate housing, such as the suggested models by Dr. Quilty, and sustainable youth programs, such as those once run by WIDAC that had ground to a halt, tragically, during the time of the inquest, but we hope are currently being enlivened. It's why Aboriginal elders should be empowered to lead those changes. One recent development that appears to be extremely promising is referred to in the submissions of the Paramparoo Committee to paragraph 265, and that relates to the Kurtaji Weta Leadership Group, and I'll leave Mr McMahon to submit more in relation to that. In Chapter 7 of your Council Assisting's written submissions, there are draft recommendations directed to practical strategies to prevent youth crime and to stop the cycle of conflict that Kumanjayi experienced. I move now, Your Honour, to topic 2, stressing, of course, that this is just a brief summation of the detailed written submissions, but topic 2 in my oral submissions relates to the events of the 6th of November 2019. Ultimately, the submission made by your council assisting team is that Your Honour would not be critical of any of the efforts of Senior Constable Christopher Hand and Sergeant Lanyon Smith on the 6th of November 2019. On the contrary, they were thoughtful officers who cared about community and showed great restraint on that day after attempting to arrest Kumanjayi when he pulled out a small axe and waved it in a way that was menacing and would have been frightening at the time. Your council assisting team urges Your Honour not to downplay the seriousness of that. There's no need to. It's accepted that Kumanjayi was loved, was capable of great love, and that he did not have the supports that he deserved when he was growing up, and he was, in Sergeant Jolly's language, let down by not having had the supports, including testing and support to overcome the FASD and trauma. But what it led to was a conflict with police on the 6th and the 9th. That was disturbing. Lottie and Eddie Robertson are respected elders, and when they were speaking to Sergeant Frost the next day about what happened, they clearly understood the seriousness of the events of the 6th of November. They were sorry that it happened, and it would have been genuinely frightening for the police officers involved. The reason that it was not anticipated by Officers Hand and Smith is that Kumanjayi had been arrested without incident on a number of occasions prior to that time. Those two officers were not expecting this behaviour. Unlike the officers on the 9th of November, which I'll come to shortly, there had been no recent event where Kumanjayi had exhibited violence of that nature, which would have elevated his risk profile. As the court knows, of course, Kumanjayi breached his suspended sentence in October 2019 by removing an electronic monitoring bracelet just 1 week after his release to an alcohol rehabilitation centre. That wasn't a technical breach, but it is a shame that there was no opportunity to have him return to the program after that point. And Your Honour might make comment about that in your findings, but no evidence was called from the rehabilitation facility where he had been residing before the breach, and Your Honour would not be critical of that facility. The breach of the order led to a warrant being issued for his arrest. Some of the families for Kumanjayi urge Your Honour to be critical of Officers Hand and Smith for attempting to arrest Kumanjayi on the 6th of November, particularly when there was a funeral for family planned that weekend. But with respect, I make a number of points to submit to Your Honour that you should not be critical of Officers Hand and Smith. First, there had been a series of break-ins overnight in the nurses' homes, which would have been upsetting and disruptive and frightening. Kumanjayi had previously broken into houses. It was not a stretch for police to think that he might have been involved. True it is that after the break-ins, when fingerprints were dusted, Kumanjayi's fingerprints were not found. That doesn't mean he wasn't involved. And in any event, proactive policing would have justified further inquiries as to his whereabouts and whether he was involved. Second, there was a warrant for his arrest. And third, the attempted arrest by Hand and Smith occurred on a Wednesday. They were not aware of the funeral plans for Friday. And I commend to Your Honour the evidence of Officer Smith on the 15th of September 2022 at transcript page 567 and Officer Hand on the 19th of September at transcript page 648. The fact that police did not know about the funeral speaks to a disconnect at that time between what was happening in community that was culturally significant and what was happening with police. Had there been a better conduit between the community and police, those funeral arrangements may have been taken into account. They might have then been the subject of discussion, for example, with ACPOs or appropriate elders. The evidence suggests the need for a better source of communication and conduit for communication, and that is one reason why Kumanjayi Wita may be so helpful and why there's room for further reflection on that and potential recommendation. By November 2019, Officers Hand and Smith were experienced at times in a disparaging way, but community police officers, Your Honour heard, perform an essential role. Many police officers are very proud to serve their communities, and so were Officers Hand and Smith. They were skilled, empathetic, dedicated, hard-working police officers in the Northern Territory who cared about the community. Lanyon Smith graduated from Police College in February 2007. For most of his policing career, since about 2010, he had been working remotely. He worked in Haas Bluff, Papunya, Imampa, Hermansburg, Ontario, Kintore, Yuendamu, Woolaura. He spent his early years as a child in Queanbeyan, not far from where Mr Rolfe grew up, and he had not had much experience working with Indigenous people before he worked with the Northern Territory Police. But as Mr Coleridge of Council put it to him in his questioning, he'd had a real tour of the Southern Desert and he appreciated the importance and benefits of that work. Officer Hand graduated from Northern Territory Police in December 1995. He went out to Yuendamu in 1997. He spent time in the Mataranka community. He spent time in Minyeri, Jilminkin, Mulga Camp, and he relieved in some of the remote communities in the southern region and spent time in Wadeye. He also worked in the city areas in Darwin and Alice Springs. In terms of what happened in the House on the 6th of November 2019, your council assisting's written submissions suggest to Your Honour that after Kumanjayi produced the acts, Officers Hand and Smith showed significant restraint and courage. The court would find that they handled it well, with a minimum amount of force based on their knowledge of Kumanjayi and their experience in the community with him. Your Honour may find relevant the evidence given by police psychologist Mr Van Heften on the 3rd of November 2022. In cross-examination by Mr Officer in relation to the events of the 9th of November, this was put to him. Mr Officer said, so for example, if a police officer has never been involved in a situation where in very quick time they are subjected to a rapid and violent assault, that wouldn't necessarily be one of those instances where you say they'd been desensitised because of an overexposure to situations, would you? It's completely different to the repetitive conduct that might give you desensitisation. Do you agree? And Mr Van Heften said, I agree. Exposure to a unique event that someone hasn't experienced before is different to repeat exposure to an event. Mr Officer continued, yes, and so in those unique events, when we talk about characteristics and having in your mind your qualification, which I read to you, it's a psychologist, Is it the case that an individual in that situation would fall back on their training and decisions they make in that moment? And he replied, the psychologist with his expertise, I would say the decisions that they make, as well as the training, will be influenced by their attitudes and values. In that moment, faced with a decision about how to react to Kumanjayi producing the acts, with their knowledge and experience, those police officers didn't think Kumanjayi wanted to hurt them. They stood back, they gave him room to escape. Their values were on display on that day, their attitudes and their values. Their values were exemplified in the email exchange subsequently between Officer Hand and Assistant Commissioner Worst. On the 7th of November 2019, Officer Worst sent an email to Officer Hand checking on his welfare, which was commendable. In the course of the reply, Senior Constable Hand writes, I don't think he wanted to chop us up, he just wanted to escape. No one was injured, and that's the best result, in my view. I trust all is well with you. No posturing, no exaggeration. Rather than celebrate the use of force, Officer Hand celebrates the fact that no force was used and no one was injured. That was the best result, in the view of Officer Hand. Both officers would have impressed Your Honour as mature and credible and of significant value to the police and the community of the Northern Territory. I come now to a third topic, former Constable Rolfe's history and the relevance of it to understanding the events of the 9th of November. Those events cannot be seen in a vacuum. Your counsel assisting team rejects the submission made on behalf of Mr Rolfe that examination of the cause or circumstance of Kumanjayi's death insofar as it relates to Mr Rolfe requires only an understanding of the events of the 6th of November to the 9th of November 2019, since they are the only dates that he had any involvement with Kumanjayi. I can understand why that is put on his behalf, since it would avoid scrutiny of behaviour that is highly problematic. But that behaviour is relevant to an understanding of the subsequent events on the 9th of November. Contrary to the complaints made on behalf of Mr Rolfe, scrutiny of those events during a coronial investigation is not an example of an adversarial style of inquiry. It's not done in order to be overly critical of Mr Rolfe or to demonise him. He is no doubt a young man with considerable intellect and skill. He is more than the sum of what happened on the 9th of November, and he has had to endure the stress of the trial that followed Kumanjayi's death. His actions should be seen in context, and the positive aspects of his policing put forward on his behalf by those who appear for him will no doubt be taken into account by Your Honour. It also must be accepted that he worked in a stressful and demanding job where he was exposed to traumatic events. At times in the Northern Territory Police, he got poor supervision and poor mentoring, and his mental health had deteriorated by the 9th of November 2019, as his text messages demonstrate, although he did not alert his supervisors to that, and neither did the senior officer who he exchanged text messages, who became aware of a deterioration in his mental health. But Mr Rolfe's legal team urges Your Honour not to sugarcoat what happened with respect to Kumanjayi's behaviours on the 9th of November, and neither can Your Honour sugarcoat the actions of Mr Rolfe. On numerous occasions in the lead up to the 9th of November 2019 and on that day, he acted in ways that were undisciplined, ego-driven and contemptuous of authority, particularly contemptuous of a female community police officer, Sergeant Frost. And those attitudes are relevant to the death of Kumanjayi Walker. Ultimately, and I'll take Your Honour to these submissions shortly, the evidence shows that Mr Rolfe was a man whose ego was wrapped up in his use of force, and ego had a lot to do with the tragic events of the 9th of November 2019. I contrast the humility and restraint of the officers on the 6th of November 2019, and I contrast the humility and care demonstrated by senior officers like Superintendent Nobbs, Sergeant Frost, Assistant Commissioner Worst, and colleagues like Hawkins and Ebel in the IRT when they reflect on what happened on the 9th of November and they brought their reflections to this court. Perhaps, Your Honour, Mr Rolfe could have been shaped to be a more disciplined officer with better mentoring and a better disciplinary process and a system of acting on red flags. Perhaps some of those tendencies and problematic attitudes could have been brought into line, but this court will never know. In the submissions of counsel assisting, we've carefully set out former Constable Rolfe's brief career in the Northern Territory Police, and we stand by the findings urged of Your Honour. For example, there are findings urged on Your Honour in relation to the recruitment process that Mr Rolfe engaged in, paragraph 234. It's noted that Mr Rolfe applied to join the police force on the 2nd of February 2016. Three broad issues emerged from Mr Rolfe's application to join the Northern Territory Police Force. There was evidence of dishonesty by Mr Rolfe during the application process, and that is set out carefully. There was evidence of the results of psychometric testing of Mr Rolfe when he participated in the application process that should have been red flags that could have been come back to and reviewed. The third was evidence in relation to the decision by the Northern Territory Police Force not to seek Mr Rolfe's ADF file, that is his defence file, which meant that they did not find out about his dishonesty with respect to a previous disciplinary process in the Army. Throughout that paragraph 236, we've taken some care to identify what the dishonesty in that application process was. And I don't need to read it onto the record, but having found the primary facts relating to Mr Rolfe's dishonesty, which included the failure to disclose the fine in Queensland for public nuisance violent behaviour and the failure to disclose that he'd previously applied to join the Queensland Police Force, Your Honour would find that he lied in his application to the Northern Territory Police Force in order to improve his chances of success as an applicant in the Northern Territory Police Force. And Your Honour is entitled to have regard to the body of evidence in relation to Mr Rolfe's dishonesty when determining whether or not it's probable that he told a lie on a particular occasion. Your Honour should also find that the Northern Territory Police Force recruitment process at that time was inadequate or deficient. It didn't take the necessary steps to substantiate the self-reports by applicants in relation to the ADF, and because of that, Mr Rolfe's dishonesty wasn't identified. In relation to psychometric testing, as set out in paragraph 241, it revealed that three issues of significance. After making a mistake, Mr Rolfe was less likely than others to accept responsibility. He may brush off the significance of the error, seek to minimise his own role or to blame others. Second, the aggression score was above average, and it noted that whether he will act with firm assertiveness or frank aggression cannot be determined from this scale alone. Third, the friction between Mr Rolfe and his father was a pattern frequently found to be associated with later resentment of authority figures in highly structured organisations in which employees are expected to comply with strict procedures. That psychometric testing didn't mean that Mr Rolfe wasn't or shouldn't have been eligible for the Northern Territory Police Force, but it was a powerful tool where if there were red flags in the future, it may have been of assistance to the Northern Territory Police Force. Certainly in this inquest, some of those issues raised were evident. Your Honour should find with respect that the psychometric testing, while by no means conclusive, ought to have been considered by those responsible for supervising Mr Rolfe when concerns began to be raised from late 2018 about his use of force and his dishonesty. To adopt what Your Honour's previously said in ruling number 3, what the police force learnt about Mr Rolfe during his recruitment called for a greater degree of ongoing supervision and or assessment to determine his suitability as a police officer, and in particular, his suitability for deployment with a tactical team like the IRT. In written submissions from paragraph 163, Your Honour is urged to make findings in relation to Mr Rolfe and the inadequacy of his supervision and lack of discipline by the Northern Territory Police Force at times. Put briefly, and this is at paragraph 164, the evidence demonstrates that Mr Rolfe was a man with a tendency towards violence and who had expressed negative and racist beliefs about Aboriginal people and derogatory beliefs about bush cops and more senior female officers. He was prepared to give accounts, including in evidence to this inquest, of his use of force that were dishonest. He had little regard for authority and he was contemptuous of more senior officers, particularly when they were critical of him or his conduct, or where he, a junior constable with less than 3 years' experience as a police officer, thought he knew better. If Your Honour finds those immediate facts proved, they are highly probative of in relation to the cause and circumstances of Kumanjayi's death, whether by reasoning akin to tendency reasoning because they shed light on Mr Rolfe's character and state of mind, or because they go to his credibility as a witness in relation to the events of the 9th of November 2019. In addition to the proposed findings about Mr Rolfe, they should be considered in the context of findings of the failure of the Northern Territory Police Force to adequately supervise or discipline him at times. Paragraph 166, we set out a summary of the findings sought in with respect to Mr Rolfe, and they're not resiled from having read the submissions in reply. In respect to the attitudes held by Mr Rolfe that increase the probability of Kumanjayi Walker's death, they are these, and I stress, Your Honour, they increase the risk of what happened on the 9th of November. Mr Rolfe held and expressed overtly racist attitudes towards Aboriginal people. To the extent that he gave evidence of a broader culture of racism within the Northern Territory Police Force, Your Honour will have to weigh up that evidence. Your Honour will have to weigh up the entirety of the evidence of Mr Rolfe, and you may accept some of it and reject others. The evidence that he gave belatedly of racism, particularly the certificates in the TRG, was self-serving, and it's difficult to try and comprehend whether or not Mr Rolfe was he impacted on it himself. That is, at least in relation to the certificates, when he was a serving officer. But certainly the evidence he gave of some people, police officers exhibiting racist language and behaviour, was borne out by the fact of the certificates, the evidence of former Officer Campagnaro and his own evidence, that is, the text messages which revealed some officers had engaged in racist language and were racist. Mr Rolfe expressed and worked with other officers who were likely to have reinforced the sexist attitudes towards female police officers. He held, expressed and worked with officers who were, some of whom reinforced derogatory attitudes towards community police or bush cops. He had little regard for authority or the rules, at least where it didn't suit him. It provided an opportunity for him, in his words, to get some cowboy shit done in his words, the Wild West. And that increased the risk of what happened on the 9th of November 2019 happening. In respect to Mr Rolfe's use of force in particular, it's important to understand why that is relevant to Your Honour's consideration of the 9th of November 2019. Mr Rolfe was a man whose ego was wrapped up in his use of force and who took pride in and derived a sense of worth from expressing his dominance over others. They were generally Aboriginal men, and he expressed that dominance through the use of force. When Mr Rolfe used excessive force, he advertised it to some of his colleagues because he thought it was funny. When taken together with a myriad examples of Mr Rolfe sharing media about his use of force inappropriately and potentially illegally, or boasting about his use of force, that conduct is reflective of his fascination with violence, or at least his glorification of it, and the sense of impunity with which he approached his work as an officer in the Alice Springs Police Force. He had a tendency to use excess force, and Your Honour may find that where one use of force option was reasonably open to him, he would prefer to use the more forceful one. In his own words to Miss Campagnaro, he was always the first to get his gun out. He had a tendency to rush into situations without regard for his and others' safety. He had prioritised getting his man over virtually all other considerations. He had a tendency to seek out situations in which force would be necessary because he found combat situations exhilarating, because they provided him with an opportunity to demonstrate his prowess as a young, fit and effective police officer. And that contributed to his sense of self-worth. Mr. Rolfe had, and he knew that he had, a tendency to overreact or, to quote him, lose his shit when people pressed his buttons. Towards the end of his time as a police officer, he was aware that he was becoming increasingly volatile in the context of his declining mental health, and that's clear from the text messages with CV. He had a tendency to act dishonestly in the context of his use of force. And taken together, Mr. Rolfe's tendencies to seek out situations in which force would be necessary and to use force excessively or inappropriately, the pride he took and the amusement he derived from his use of force, even where excessive, and his inability to accept criticism of any excessive use of force, demonstrate that he had warped attitudes towards the use of force that made him dangerous as a frontline police officer as at November 2019, because it increased the risk of what happened on the 9th of November 2019 happening. And so you can look at the body-worn video of Mr. Rolfe on the 9th of November 2019 and hear submissions about him using polite terms or terms he thought were polite prior to the interaction with Kumanjayi Walker. And you can hear him use a soft voice, but that doesn't detract from anything that went beforehand and the clear evidence Your Honour has of the tendencies to use excessive force on occasion and to rush in where other options were open. In respect of Mr. Rolfe's credibility, Your Honour would find that he was prepared to dissemble in this court and he does not have a credibility as a historian in relation to his use of force. You can have regard to his demeanour as a witness. You can have regard to his inability to make reasonable concessions at times. You can have regard to